166. What did we say? Currencies, no? False currencies. And then 67 is mutilation of currencies, importation of there's of mutilated coins and of mutilated currencies. And then 169 is counterfeiting, importing, altering instruments not payable to bearer. Maybe, siguro maybe ask the BSP. Are those equally bad?
Maybe ask you, maybe ask Your Honor, the representative from Bangko Sentral, which crime is
Yes.
worse? Is
Yes.
it counterfeiting or importing the impact to the economy, Mr. Chair?
Oh, sa kay Attorney Andrew
Yes, Your Honor. Good
Rin, no?
morning.
Yung okay,
Documents not payable to bearer may represent a far higher value than that represented or that may be counterfeited with respect to currencies. Uh, Unlike currencies, these documents that are not payable to bearer may represent millions of pesos.
that's
Unlike
speculative.
yes, Your Honor, but
The purpose behind the law, which is to
I
protect,
agree.
and that is the old law, and the situation that you as a body as a whole, whether we're going to veer away from the old approach in the RPC requiring participation of connivance when it comes to catering, but because that's how the old Spanish law views catering as a punishable act, but you didn't really find how demonstrating to us, Your Honor, that it could not be confined in those instances.
Thank you for the compliments.
Uh,
Um, but
so we have to decide, Your Honor, whether we're going to revert to the old law or we're going to
Good morning, Mr. Chair. For me, if kung ako lang,
Mm.
I would rather treat it as an aggravating circumstance. From the viewpoint of a prosecutor, we don't have to prove the connivance already. So mas madaling i-prove, mas konti yung elements na mapuprove namin.
Uh, it's easier. In other words, if you can prove knowledge, then that is enough.
It's
Yeah, you have more room.
yes, more room.
Unlike here, you have to prove connivance. Although it's hard to prove knowledge, it's really circumstantial. Like in the case of Ida, Lorna, Ida and Lorna, where Ida is known to be in the business of falsifying checks. And so Lorna knows that she does that, and then she obtains checks from Ida that she knows.
Although both of them are, you can basically prove them through circumstantial evidence. Maybe in some cases, may direct evidence pa, but mahirap kasi i-prove talaga yung
Yeah,
connivance.
knowledge is broader than in connivance. No? Kasi you can prove it in other ways, in ways other than conniving. Tama? So your prosecutor Amido proposes to uh, treat, and also for consistency's sake, treat connivance as qualifying. Justice De La Rosa.
Thank you, Mr. Chair. Um, so if I may just ask, may I ask the resource person, so if I utter,
Simple.
yes, if I utter uh a note not payable to bearer, I may be held criminally liable. If you want it as a qualifying, aggravating circumstance. So the mere fact that I receive a check payable to bearer and I utter it, I use it.
Uttering connivance.
I'm okay po, Chair, with knowingly utter.
Knowingly
Yes,
utter.
yeah. As
So,
long as there's that qualifying, Mr. Chair.
so the view of Justice De La Rosa is actually shares the view of Prosecutor Amido. Knowingly does knowingly is enough. So that is reason to actually, and there wouldn't be a qualifying circumstance. Connivance would not be a qualifying circumstance for Articles 166 and 167. Maybe hear from the public attorney's office. Banggit yung name nyo para
Attorney Angela Hernandez
yeah.
from the Public Attorney's Office. Sir Chair, can we propose that, okay, we will adopt the uttering knowingly or knowingly uttering the instrument that's not payable to bear. But, so, wag na natin gawing aggravating yung
And
indictments.
it wouldn't be consistent with the proposed Article 166 and 167.
Yes, but because, I think an instrument that's not payable to bearer should be treated differently as opposed to those
Yun.
other
Okay.
instruments such as
Why?
cash.
Why should it be treated differently?
Cash, for example, kasi we are treating, uh,
Like, and
yes,
just
cash or a check payable to bearer is easier to transfer from one hand to another.
mm,
This one, this is more difficult because as earlier mentioned by our DOJ representatives, you have to endorse it first. The instrument is already already indicates a name that it has to be paid. You can go for such a short transfer of funds only as compared to the one payable to bearer of cash that can be more widespread.
but here's a question. If you knew that it was falsified, the check that was payable to order, why must the prosecution still prove that it's in connivance when you already know when you uttered it, when you uttered the instrument payable, payable to order, okay? If you knew it was already falsified, right? Why should in connivance still be an element? Di ba? Mali na yun.
Uh, that's why, Mr. Chair, the proposal is retain the knowingly uttered, but don't make the connivance as aggravating.
You also proposing then to strike down um, in connivance.
Uh, and connivance is also considered as knowingly uttering.
No, 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 no. I mean, if you connive, then you know, but you may know without conniving. So the question is, you
Treatment
know,
is the same, Your Honor.
no, should we retain in that case in connivance? Because if you already know, you're saying, um, why should you make it more difficult to prosecute somebody under Article 169 by adding in connivance when it is not really necessary? Because you can merely prove that he knew that it was a falsified instrument.
Your Honor, your proposal is we're okay with knowingly uttering without connivance.
Oh, okay.
Right? Don't make the act in connivance as aggravating.
Yeah, well, if you take out in connivance, then there's your second concern is has already been will be addressed. He said, don't make in connivance qualifying. But if you take out in connivance, as you earlier proposed, you said knowingly utters is enough, you said, right? So that you can do away with in connivance. And then in connivance will not be qualifying, but it will be qualifying because in the first place, it's no longer stated in the article because you deleted it. Do you follow? Sabi mo kasi, yung knowingly, sapat na. So, hindi na kailangan in connivance. Pero sabi mo, it's not ano yan. On the other hand, you said, well, in connivance, pwede, pero kung gagamitin qualifying. Yung on the other hand, wala na yun kasi tinanggal mo na sa first eh. Diba? So, but I get the penalties provide insight on which crime is graver. Yun ang titignan ko. Now, looking at the, tingnan natin. Well, definitely if you look at Article 165 of the revised penal code, one penalty lower in degree, no? But tapos 166, ano yung penalty na ano? Article 165 of the revised penal code makes reference to preceding articles. The preceding articles would be, ano ba yung preceding articles nun? Ano muna yung- The base penalty for knowledge. I'm sorry, for the preceding for the articles preceding Article 165. The base, ano yung base penalty? 64. So under Article 164, 164 RPC, PC minimum, and then 163. Art- Under Article 163, the Vice Penal Code, Presyon, Correction, Minimum, Medium. Okay, you like that? Are those the only preceding articles? That's it, no? So Article 165 says, 165 says that mere knowledge, no? Without connivance would be one lower. So that would be, if it's PC minimum, arresto mayor. Kung knowledge lang. Under Article 165, the revised penal code, no? Would that be arresto mayor maximum? AM maximum? And for 163, 163 of the revised penal code, if it's mere knowledge, minimum, medium, ano siya, arresto mayor din. So that would be arresto mayor. Medium to maximum. Yan ang, that's the graduation of penalties under the revised penal code. So you compare that with the graduation of penalties here. The 166, it is prison correctional. Minimum, no, 166 is prison correctional without the full range of prison correctional. And then 167, it is prison correctional Knowledge is really personal. Either you know it or you don't. But the moment you coordinate with the counterfeiters and other people, it takes it to another level. Yun ang sinasabi niya, eh, 'di ba? So therefore, it should be more severely punished. Yun ang sinasabi niya. Knowledge is could be a personal thing. Alam ni Lorna na si Aida namimeke ng cheque. Pero in connivance introduces the idea, the introduces parang coordinated activity. Kakuntsaban niya si Aida. She connived. Lorna connived with Aida. So, aggravated yung penalty niya. Now, to support the view of Attorney Aspirin, again, the default.
Honor. I have a suggestion wherein we can default to the RPC and at the same time preserve the distinction between knowledge and connivance. Um, based on a based on a review of all the three drafts of Section 2 and Section 3, I noticed that both HB 474 and 7142 did not make any substantial revisions to the RPC. The only substantial revision was that it incorporated the connivance under Section 2 to include it as the second paragraph of the two. So my first suggestion would be to revert back to the RPC. And in that way, we can still maintain under Section 2 that under Section 2, we can maintain that there is connivance under Article 163 and 164 of RPC. And then we have the knowledge only under Article 165. Now, to reconcile our problem of maintaining that there is a distinction between knowledge and connivance, we can also emulate Article 165 under Section 3. So under Section 3, we will have Article 166 payable to bearer. This is where there is a constitutive element of connivance. Article 167 payable to bearer. Connivance is also an element here. And then we can add an additional article similar to 165 wherein a person who only knowingly holds counterfeited payable to bearer or not payable to bearer can be penalized one degree lower, similar to Article 165. With that suggestion, we can revert back to the RPC and at the same time, we can introduce the concept of distinction between knowingly and connivance. Make this framework similar to Section 3. This Section 3 is for negotiable instruments. So for Section 3, we will have Article 166 and 167. This deals with connivance for two different types of negotiable instruments. And then we have another article wherein we will penalize those who only knows without connivance, one degree lower. So we will applicate Article 165 under Section 3 specifically for negotiable instruments. Because the problem here, I believe, is that 165, the without connivance, it only deals with coins and it doesn't apply to negotiable instruments. So we can make the framework similar. So
Article 165 also include other instruments.
we can make your honor, since these are two different sections, we can make another article below which will be specifically for negotiable instruments so that we can still preserve the RPC.
Okay. Views? Oh, given the indecision, apparent indecision of the body, then we should default to the RPC. That is a reason to default to the RPC. Kasi undecided eh. Undecided tayo. Or there's no like strong sentiment either way. You know? Do you agree? Di ba? Status quo. Pagka when in doubt, status quo. So maybe perhaps the approach of attorney Estigoy would do. But
May request na rin, ano, to
yes,
make
that is
this okay, ano, so that we can
can you attorney Estigoy before the end of the day of the meeting? By the way, we have to wrap up at 1 o'clock. 1 o'clock. Can you come up with a finding?
technology, then just resolve.
Yes, you're-
So
we have no problem. We'll
So-
definitely take the homework.
okay, where are we now? 160, 69. But then, how would you? Oh, there's uh, from the public attorney's office. Yes.
Good morning, Mr. Chair. Attorney Benito from
Anybody?
clarification lang po, especially sa mga taga-DOJ. Tama po ba na kapag na-charge ang isang accused ng uttering ng in connivance with counterfeiters or importers, yun lang yung magiging charge nila? And hindi nagkakaroon ng possibility na may iba pa silang charge. Kasi pwede kayang maging principal by inducement sila sa isang counterfeiting or importing.
Oh,
Kasi for example po kanina, what if sinabihan ni Lorna kunwari si Fe, "Igawa mo naman ako ng fake na ano, na na instrument."
hindi namimigay kasi si Aida na nila.
Si Ida, parang gano'n po. So, tama po ba? Kasi nagkakaroon kasi ng interchangeable na meaning yung connivance tsaka conspiracy. So, baka lang ang iniisip ko baka lang kasi may time na magdoble-doble ng charge.
Okay.
Can
Are you
we
concerned about conspiracy? Conspiracy, no? If you're if connivance is if connivance is tantamount or amounts to conspiracy, there will be principles. Is that the
Yes,
question?
Mr. Chair, by inducement.
By inducement. Prosecutor. Okay.
Mr. Chair, thank you so much. So in answer to the question of Attorney Marido, the prosecutors actually have great discretion on what charges to file. It doesn't mean po na ito yung um, final na case ng law enforcement agency na yan na po talaga ang ipa-file. You have to remember po, meron po tayong case build up. So, kapag nakita po ni prosecutor na hindi lang si Aida yung may liability, pati na rin po si Fe at saka si Luna. So, yun po ang file ni fiscal. Hindi po based on what the law enforcers stated in their complaint affidavit po. So, minsan po, yung mga defense counsels, nagugulat sila kasi sinasabi nila, ito yung final namin ng law enforcers against the respondent. However, if the prosecutor finds that there are, in fact, hindi lang po under the same law. Kahit may ibang special laws na na-violate nun po, isa-file rin po yun ni fiscal. Thank you po, Mr. Chair.
Prosecutor Campo, you wish to say something? Or?
Yes, Your Honor, I agree with my good friend Chief Sheila na talagang we do not rely merely on the nomenclature or denomination on the case referral filed by by the private complainant or by the law enforcement agencies. Whenever we are able to deduce from the facts as appearing the complaint affidavit, we can file other charges aside from those being referred to our office. So, and as far as knowledge and connivance is concerned, it is two different things because you may have the knowledge, but it doesn't follow that you will connive with the forger. So, If you have knowledge, then you can only be charged with that particular crime wherein knowledge is an element. But if you connive, then that will constitute conspiracy, Mr. Chair.
Or if you connive, okay, is connivance the same as conspiracy?
Your Honor.
Yeah, first one come.
The same, Your Honor.
It would be the same, yes. Right. Except that this would be an exception to the, yung, well, if it's treated as an element of a crime, then it takes it out of the, yung mode of incurring criminal liability. So what are you proposing? What is the, uh, how should we approach and handle this matter?
And that we revert back to the RPC and maintain the same framework because I believe there is the wisdom behind the difference in treatment as to the
Yes.
nature of the instruments and the coins. So if we are going to revert back to the RPC, I think it would be best that we do not merge these articles and
Yeah. There's a danger in what of them. Okay. In avoidance of work, the DOJ is amenable to the proposal. But then the burden is now on Attorney Steve, huh? To define the language, Yung mga, can you consult with the committee secretary on the particular wording, currencies and all of that, you know? Attorney Steve, when is it due? When can you submit?
before
I'm
the
not as
next.
strict as Justice Nilamusan.
If it is amenable to your honor, I can submit it before the next hearing.
Oh, sige. Kung ano is the next hearing. Mhm. And just to the just to make this a little bit more challenging, we have to align this with the passport law, the new passport law, and we have the presence of the DFA here. What's the particular issue? Yes. So why? Forward. Okay, well, first, on Article 173, there was a suggestion just to backtrack to a suggestion to include visas, and supporting documents, right? And then the concern was raised whether this is uh, uh, reflects, word for word, the relevant provision under the new passport law. Okay, 11983. But before turning to DFA, maybe hear from Prosecutor Almido.
Regarding the issue on whether to include visa, sa tingin po namin, ang determine kasi kung falsified yung visa is kung saang bansa nanggaling yun. For example, sa American visa, they will be the best ones to say kung falsified ba yan o hindi. So, my suggestion is not to include visa sa mga documents na yun nandito. Thank you, Mr. Chair.
173. Well, if it's a Philippine visa,
So,
what if an operation that falsifies foreign visas?
And Your Honor,
Kunyari, dyan sa Divisoria, may gumagawa ng visa, ng US visa, which fake. You don't need the American perspective to say that it is fake.
Your Honor, Mr. Chair.
Si Prosecutor Ricamora.
And besides, that can be remedied. We can always request the appropriate embassy officials of the country
To testify.
to testify and tell the court or present evidence or to make issue a certification that in fact their visa was falsified.
Yun ang gusto ko sa DOJ eh. Magkasalungat kahit ang magkasama. Baka mag-asawa, ganun lang. Prosecutor Custodia.
Thank you, Mr. Chair. Well, on that particular note, Mr. Chair, we are one, but we respect our independence of
Yes.
trying to make the positive input. Mr. Chair, because the crime being punished here is falsification of travel documents. And I think insofar as travel documents are concerned, we refer to documents that are used by the Philippine government to facilitate the travel of a person. The FA is here. We do not think that in facilitating the travel of a person, visa is among the documents required because that is a document that is being issued by a foreign jurisdiction authorizing someone to enter their port or their ports of entry. But insofar as Filipinos are concerned, travel documents are those which are being required by the Philippine government to facilitate the travel of our citizens. So in that particular regard, I humbly submit that visa is not to be considered a travel document. Thank you, Mr. Chair.
Okay. A foreign visa is issued by the foreign embassy. Correct? In the Philippines. But if there's an operation in Divisoria that falsifies foreign visas. How would you treat that? How should that be penalized? Falsification of document.
I don't think so because in the case of falsification of documents, the law specifies specific documents. These are the public documents and the official documents, meaning, in my humble opinion, Mr. Chair, these are documents issued by Philippine government officials and Philippine government.
So what are you saying? Given the gap, we should fill in the gap. We should include visas in it. I'm just playing devil's advocate. There's a gap. If it's not penalized, address that to fill the void. You include visas.
Mr. Chair,
Prosecutor Cristobal.
then I think it's not considered a criminal offense because the reason why the law punishes falsification of public documents because it destroys the public trust insofar as our own documents are concerned. And if we tamper on a document that is
Implementing that because penalized for that.
that is a violation, I think, of the laws of the foreign jurisdiction, Mr. Chair.
Yes, but it will detain, but Filipino citizen would be detained. The Philippines has an interest in making sure that Filipinos are not unjustified, are not detained without just cause. Prosecutor Cristobal.
Just to elaborate, Your Honor.
We could, well, first, if you say travel documents, it'll raise this ambiguity of whether or not it includes a foreign visa, a visa, right? Ako, the way I see it, the state has an interest in protecting its citizens, traveling abroad. Mhm. Foreign prosecution for bearing a falsified visa. Kasi mananagot yan, you will be detained abroad. So if you have an opportunity, right, to address that and prevent that, why wouldn't you do that by penalizing falsification of visas, whether foreign or local? Um,
Your Honor, can we just first stick to the draft of Article 173? The proposed provision only states any passport. So there's no reference as regards whether it is a Philippine passport or foreign passport. So what is the policy direction of this committee? Are we going to include foreign passport? Because that is a travel document. Or we're going to limit it to Philippine passport. for Mr. Chair.
Tingin ko, any project, maybe hear from the Foreign Affairs on this. Article 173, page 124.
Your Honor, good morning. I'm Attorney Ren Salinas from the Office of Consular Affairs of the DFA. Your Honor, this is a question that is raised for in the first instance in this hearing, and we will have to defer to our principals on the question on whether foreign passports should be included. However, based on jurisprudence and historically, foreign passports are not necessarily included in what is deemed to be in the revised penal code in the context of this provision. However, if we are to subject it into a new interpretation to include foreign passports, then it's given our positions, we have to, given our level of representation here, we may have to raise this with our principals first, Your Honor.
Well, the first question is whether this is consistent, word is consistent with the new police program.
Yes, Your Honor.
Is it consistent?
Uh, well, there is no conflict, Your Honor.
So it's word for word.
Uh,
How new
not,
police program.
not word for word, Your Honor.
How is it different?
Just,
Good morning, Honorable Chair.
Mm,
Luciano Hoson from the Office of Treaties and Legal Affairs.
mm.
Um, it appears that the proposed Article 173 is not lifted from the Passport Act word for word, because as an example, if with the permission itself. To the use of passports whose invalidity may arise from an official administrative determination independent of the document's physical condition, Your Honor. we respectfully submit our comments.
But you said your colleague, whose name I can't read, sorry,
Attorney Alinas.
Attorney
Renz, sir.
Alinas, mentioned that it's aligned. It's aligned with the new passport law. You're saying that it's not word for word, it's still aligned with the passport law? Is that the
My apologies, sir. What I intended to say was that it does not have the effect of being in conflict with the passport law, sir.
not in conflict, therefore aligned? Not necessarily.
Aligned but not word
Ayan,
for
hirap
word.
pag abogado eh.
No, but it's not word for word, sir.
It's not for purpose aligned. Okay, but before before I indulge your argument, does the Passport Act does it apply to foreign passports?
No, Your Honor.
No, Your Honor.
It does not.
Just Philippine passport.
Just Philippine passports.
Okay.
That's right, Your Honor.
Again, with respect to integration of special laws, we have to tread carefully. To the extent possible, we should not, this is just my perspective, we should not change the wording. Because we don't know what jurisprudence has been made, has been rendered to interpret the provision. I think we might lose the benefit of jurisprudence and the guidance of jurisprudence if we change the wording of special statutes that are integrated here. You know, so DOJ, I don't know why it was changed. But I do understand why apparently you have broadened it. The DOJ has broadened this by stating any passport. So any passport for me means even a foreign issued passport. And if that is the case, then there's little distinction or no distinction between a foreign passport and a foreign visa. You know, so therefore we should also include visas. Now, is it bad to falsify foreign visas and passports? Yes. And if we in the Philippines have opportunity to actually prosecute that, I think we should do that. I think the foreign embassies and our other nations would be happy that we're doing that. And we don't know if they have reciprocal laws that also falsifies, that also criminalizes the falsification of Philippine passport in their respective countries. Merong reciprocity angle to eh. Hindi ko, but let's hear from Professor Borja. We'd like to, unfortunately, Justice De La Rosa has to leave to join his colleagues in deliberation. We would like to thank your participation, Justice De La Rosa. Wag ho kayo magkasawa. Maraming salamat po. Professor Borja.
Thank you, Your Honor. For context, this newly added provision on Article 173 of the bill was inspired by the old Philippine Passport Law, Republic Act 8239. And I think this was enacted 1996 pa po. And then it's not a faithful reproduction of the amended Philippine Passport Law, which is Republic Act 11983, which was only enacted 2024. So perhaps the conflict that we're having now is simply because the former TWG back then, I think from 2014 up to 2023, ginagawa itong draft po with the DOJ. That's why may mga discrepancies.
Right.
Yung economic sabotage, yung 5 or more na napag-usapan natin, wala na po siya ngayon dun sa bagong law. And then with respect to the term any passport, it was also found in it is also found in the old law,
Oh, I see.
8239. So that is where the
That
confusion.
that clarification helps. So there should be this should be replaced by the relevant provision under the new Passport Act.
Yes, Your Honor. If if the committee would decide to incorporate travel documents as a form of a public document in the crime of falsification, then we could somehow refer to Section 22 and simply Section 22 of RA 11983 and simply reproduce it.
What does it say? Section 22 of the you're citing the new Passport Act.
Yes, Your Honor.
Anong sinasabi
It
niya?
simply says that there are two ways of committing falsification of a Philippine passport, and then my only issue here is the penalty. Mas mabigat po yung penalty not less than 6 years and 1 day to 15 years. Mas mabigat po siya than any public document as prescribed in the
It's
revised-
heavier under the statute
Yes po.
than here.
Opo.
It's lighter here.
It's heavier in the special penal law.
Yes.
Opo.
Heavier than what is proposed here in the Article 173, is what you're saying.
Yes. And also heavier compared with other public documents found in the dun sa RPC po na ano.
Ako really, I hesitate to really water down special penal laws or statutes. I don't want to water them down because they've been deliberated upon, and it really already reflects congressional intent. Unless there's really a change of mind or change of heart on the part of Congress. You know, but you can't say you have a change of heart or mind unless there's overwhelming information to justify that. That is my view. Diba? Kung nagbago ka ng isip, ang tanong, bakit ka nabagong isip? What is the supervening evidence between then and now that Congress did not consider back then simply because it was not available? Prosecutor Nahara.
Your Honor, this 173 is a new provision. We don't have any existing provision in the revised penal code. That's why we have no existing jurisprudence on the matter. I agree with Professor Neil that we have to correlate this with Republic Act 11983, the new Philippine passport law, because in its section 22, there are, I think, 10 acts punishable. So one of which is regarding forgery of a passport. So this is more categorical, more clear when it comes to the acts punishable. But we have in Article 173, parang general masyado yung statement of the provisions, but the more specific provision would be found in Republic Act 11983, particularly Section 22, which is much lengthier than the provision of Article 173. If the committee would decide, we can just choose from the punishable acts enumerated in Article or Section 22 regarding the falsification or forgery. And I'm citing the Section 22, Paragraph B, which I'm going to read, offenses relating to forgery and the penalties. And there are two acts there, punishable acts. If the body would agree to adopt just the particular proviso in the proposed draft.
Or the alternative, instead of picking a provision from the new passport law, is just repeal this 173. Because we still have the benefit of the special law. As I say that, Attorney Harvey, although absent, shares the view, has the same view. He's here in spirit, in other words. Kahit wala siya rito. In his words, sabi niya, Article 173 should be deleted altogether. Okay? Retaining this will cause problems of double prosecution later on due to the common misconception that when two laws punish the same act, prosecutions under both automatically do not become a violation of the right against double jeopardy because of that misconception. This is an erroneous principle found in jurisprudence. While the state has the plenary power to define certain acts as criminal, it does not have the unlimited power to enact separate laws, punishing essentially the same offense. If this point needs further elaboration, I am willing to submit a position paper regarding this. If he were here, I would tell him in not more than 3 pages. Pero if that's the case, if it's bogged down, or we find that integration of a special law is a cumbersome process, why do we need to do it? When even without integrating it here, we can always prosecute, invoke the special law. Bakit natin papasok kung nahirapan tayo? Prosecutor Gamora.
Actually, Your Honor, that is our, at the outset, that is our direction already. If we cannot really insert provisions and the special law, then we will keep what is existing, Your Honor.
Also, the point raised by Attorney Harvey in his absence or in his presence in spirit, that this lends itself to the risk of double prosecution. Prosecutor Abadia.
Thank you, Mr. Chair. Not with the intention of putting more fuel into the fire po, no, but I found out that there's even a UN protocol against the smuggling of migrants in which member states are required to pass laws penalizing producing, procuring, providing, or possessing fake travel documents, etc. When I looked at 11983, and as confirmed by our friends from the DFA, our present law only refers to Philippine passports. However, being member states of the UN, we are even required to have a law penalizing even not only Philippine passports but foreign passports as long as it is made in order to smuggle migrants. Case in point po, Mr. Chair, yung POGO cases po natin. We had a case build up in Cebu City, particularly in Lapu-Lapu City kasi meron po silang POGO doon. And then there were a lot of foreign nationals, Malaysians, Indonesians, Thai, I think combination of Chinese. Tapos marami po silang passports. We don't have any way of knowing if they were valid or not. But there's no way of prosecuting them also for holding those passports, Mr. Chair. I just want to raise it.
So that
to
is
the
the
body.
reason to actually include foreign passports and foreign visas.
I believe so, Mr. Chair, and if the
Ako-
body will agree also.
Oh, I agree. It should be included. Is there a law, at present, is there a special penal law that applies to foreign passports or protects foreign passports and foreign visas? I don't know. Prosecutor
I
Noa.
think, Your Honor, there's none. This Philippine passport only governs cases involving Philippine passport. So with respect to foreign passport, wala po walang batas.
Was this the
If you're going to adopt this Article 173 to include foreign passport, that will remedy the loophole in the Philippine passport law because this Philippine passport law only applies to Philippine passport. So if we're going to adopt the UN protocol on the smuggling of human smuggling, then it's time. It's a proper time for the Congress to include also foreign passport.
Tama. I mean, this is an opportunity to actually comply with our international obligations. May we hear from? Sorry.
Lieutenant Torita, Mr. Chair. Mr. Chair, on the side of law enforcement lang po, we consider this kasi as one of the measures of border protection. So, although I'm not, shall we say, expert on this, on the matter when it comes to human trafficking, but I think BI and AYACAT is more. There is a study existing on this. As one of my, I attended one meeting on this. Involving also UNTOC, the UN Convention on Transnational Organized Crimes. One of the studies, Mr. Chair, the weakness, one of the weakness of this is the one measure is this the travel documents, especially in the South, Mr. Chair, wherein some travel documents, foreign travel documents, do not pass through. Because the lack of, we have lack of BI office in that area. So when any person, or shall we say, some of our citizens from one country to another, which does not pass through any ports or seaports or airports, comes into our country, the immigration cannot even mark stop the travel documents because there's no office there. So also, Mr. Chair, when in maritime operations, our law enforcers boarding the vessels, we are also inspecting documents. That includes travel documents. So if we are putting, we include in these proposed provisions foreign travel documents, that would be favorable on the part of the law enforcers, Mr. Chair. Yun lang po.
Okay. So we're still at a loss. I see the point of, why we should comply with our international obligation, and here's an opportunity to comply by including, foreign passports and foreign visas. The concern is, aligning this with the concern is on the domestic side, on the Philippine side, make sure that this is aligned with the new Passport Act, no? May perhaps the DFA can propose an article to revise this?
Yes, Your Honor, we will be submitting it. Your Honor.
Can you submit a draft? Well, one is, it has to have the following elements. Number one, it should apply to foreign passports and Philippine passports, foreign visas, Philippine visas. And then second, to the extent possible, it should be aligned with the new Passport Act for Philippine passports and Philippine visas. The other question that I'd like to ask the body is, how should it be penalized? is falsification of Philippine passports and Philippine visas more egregious or worse than falsification of foreign passports and visas? Ano ba sabi sa UN? Is there a prescribed penalty or Prosecutor Abadia?
I will skim through the UN protocol against smuggling of migrants by land, sea, and air, Mr. Chair. However, I remember in the past hearings, we have a resource person from UNODC. Maybe we can also invite them either to attend the hearing or to collaborate with the DFA in order that we will have
Will the DFA
we can align, Mr. Chair. Thank you.
will the DFA, since you're the DFA, will you all please align and coordinate with the UN
Yes, Your Honor.
just to ascertain exactly our obligation under the international treaty or under the UN, which and as pointed out by Prosecutor Abadia, she's fairly certain that we are supposed to localize the international protocol, but at the same time, on the penalty side, what is our obligation on the penalty side? Is there like a minimum under international law?
Will do, Your Honor.
Okay. Can you submit in 7 days?
Yes, Your Honor.
Thank you. So with that, we're parking again Article 173, moving on to Article 174. Bakit ang feeling ko rito parang multiple choice exam? If you don't know the answer, skip muna to the next question. Attorney Mangoba.
From OSG, Mr. Chair.
Yes.
Mr. Chair, with your indulgence po, maybe meron lang kami gustong i-point out lang po with respect to Article 173.
Opo.
In relation po dun sa foreign passport falsification or forgery, ang intention po ba is for Filipinos only falsifying or forging foreign passports, or will it include foreign nationals coming in with falsified passports po? Kasi we have the immigration lawyer, Mr. Chair. If found, the aliens, if found na with nag-misrepresent po sila in relation sa passports, yung mga travel documents po nila, ground for deportation na po yun, Mr. Chair. So, do we intend din po na kapag i-cover po natin foreign nationals with falsified passports, do we intend din po ba to subject them to yung RPC? Kasi baka po, I think the policy now, Mr. Chair, is foreign nationals kapag facing criminal charges and also deportation charges, masususpend po ang deportation case nila until ma-terminate po yung criminal case. So,
I think what is penalized here is the act of falsification, act of falsifying on our shores. So territorial. It has to be done here. In your case, it's the scenario that you describe is different. It's somebody who comes in or visits the Philippines with a fake or fake visa. Hindi po, this wouldn't apply because this penalizes acts done in the Philippines.
Your Honor.
Prosecutor Gamora.
I think 173, there are two considerations that we have to see. One is the falsification committed here. And for example, a foreign visa, a person is carrying a foreign visa that eventually found to be fake, and he intends or use here in this country, then this provision should cover it, Your Honor. That is the last portion that I've been telling a while ago, with the intent of using the same, Your Honor.
Ah, okay.
So it covers both when the falsification is done in the country and or a falsification was done in another country but it was used in this country, then this provision should apply to them, Your Honor. Thank you.
It shall be imposed upon any person who falsely makes, forges, counterfeits, mutilates, or alters any passport with the intent of using the same. But all the acts have to happen happen here. Kailangan mangyari po
Either
lahat.
falsification or the use thereof, Your Honor, or both, Your Honor.
It says the first part is in the alternative. You may falsely make, or you can forge or counterfeit, mutilate or alters, right? That's on one side. But the other one, you have to do it with the intent of using the same. Intent of using it. So that has to happen regardless. It has to happen, right? You intent naman is, but if this is if the acts itself, the intent is not an act. If the prohibited acts happen abroad, right, then we don't have jurisdiction. So it has to happen here. Tama? Yun yung ano eh.
Your Honor, about instances where falsification was committed abroad and they used the falsified document in this country. Can you also include it, Your Honor, considering that this provision already penalized merely intention to use it, Your Honor? That is
the mere intention is not penalized. And you cannot penalize mere intention.
That is the provision, Your Honor.
The overt
with
act,
the intent of using it.
Yeah, but the intent itself is not criminalized here. You have to perform the overt acts of making, forging, counterfeiting, or altering. But then you are driven or motivated by the intent of using it. So, if the intent, you're saying, if it was altered, falsified abroad, and you have the intent of using it here, una-una, you're already here. Diba? So it has been used. Parang mali na yun eh. If the falsification happens abroad, we don't have jurisdiction. Well, we don't have jurisdiction. The falsification has to happen here. Prosecutor Nohara.
Your Honor, our jurisprudence on falsification is to the effect that the act of falsifying and the act of using are treated differently. So if the act of falsification is committed in the Philippines, we have jurisdiction over it. And in falsification, it must be established the offender's mens rea. If you merely falsify without intent of using it, that is not a crime. That's why we specify here that the act of falsification must be coupled with the intent to use.
Correct.
Because mere act of falsification, even under the present setup, is not a crime without mens rea.
I'm not disagreeing. But the point made by, a question asked by Prosecutor Ricamora was, if it's falsified abroad, but the intent is here, then can you be prosecuted? Actually, that's impossible. Because the intent was born in another country. Upon falsification, the intent to use it was there. It wasn't here. Right? The moment it's here, you already used it. But Professor Borja.
Thank you, Your Honor. I do get
where Prosecutor Ricomora is coming from, and also where you are coming from, Your Honorable Chairperson. But to enlighten the discussion, we have the Human Trafficking Act, wherein it was made punishable that the introduction of any fake passport, which would serve to fake or tampered passports, which would somehow serve as an act that would promote trafficking. So, yes, I agree that titingnan din po natin yung mens rea. Okay, but if we're going to interpret the term tampered or fake passports under the Human Trafficking Act, it may somehow include the theory of Prosecutor Ricomora po, Your Honor. We have like an enabling law to support that, but only insofar as trafficking is concerned, not really the act of falsification.
Then maybe that is for another article. I don't think we should combine it here. Prosecutor Abadia, and then we'll hear from the Public Attorney's Office.
Thank you, Mr. Chair. So, in relation to using falsified travel documents, it is also provided for in Section 22B, Section 22, Paragraph B, Subparagraph 2, Mr. Chair. It says that offenses relating to forgery, imprisonment of not less than 6 years and 1 day to 15 years, and a fine of not less than 100,000 pesos, etc. And in subparagraph 2, when one uses or attempts to use or furnishes to another for use any such false, forged, counterfeit, mutilated, altered, or canceled passport or other travel document.
You're reading from what statute?
RA 11983, Mr. Chair, the one
New
that
Passport
you
Act.
mentioned. The new Passport
Okay.
Act. Thank you, Mr. Chair.
So yun, if it's treated differently there, we should treat it differently here. Diba? Dapat hiwalay din na I think the DFA, it's your undertaking to actually propose the articles. You know, kindly include in your proposal the sections referenced by Prosecutor Abadia on the introduction of falsified travel documents or falsified passports. Merong binabanggit siya from the New Passport Act. No? Kasi I think, does anyone share my impression that we're going to incorporate, but it's going to be treated, separately? There will be distinct articles for distinct articles depending on the documents involved. Professor Borja.
Thank you, Your Honor. Actually, in our previous hearings, we were able to do that, particularly with respect to terrorism and crimes against humanity. Para hindi po ma-water down nga yung essence ng special penal law, pinasok po yung mga salient punishable acts ng SPLs na yun. So maybe we could do the same with respect to the passport.
Is the DFA the best person to do that, given that we're dealing with travel documents? I have faith in you. Kaya niyo po ba yan?
Yes, Your Honor.
In 7 days. Okay. So yun nga lang, you're looking at the New Passport Act, you're looking at the UN, and you're looking at the proposed wording here. But I see the hand of the PAO raised. Attorney Barido.
Mr. Chair, this is somehow related po sa question kanina ng Office of the Solicitor General. Just to share, currently meron po kaming hinahawakan na appeal before the Office of the President. So, dito, it involves an American citizen na gumamit po ng falsified na Philippine passport to enter our country. So, ang pinagtataka lang namin, for 7 years now, walang kahit anong criminal case na na-file doon sa American citizen other than yung deportation case niya. So, Mr. Chair, imagine that an American citizen na nag-falsify and gumamit ng fake Philippine passport, nakapasok sa atin, na-intercept sa airport, yet wala pong anong criminal charge. And nagla-languish lang siya doon sa NBP kasi nandoon yung detention facility ng BI for 7 years. And presumably, kaya lang hindi siya nade-deport dahil pending pa yung kanyang appeal sa Office of the President. So, we can also consider that siguro kung meron mang void sa batas with respect to a foreign citizen using falsified Philippine passport. Thank you po.
Yung binasa ni Attorney, ni Prosecutor Abadi, I think covers that. It covers the situation that Attorney Barido described. No? Yung sa Section 22 ba yun? It covers that. So, ang gagawin ng DFA, they will propose articles to criminalize falsification of Philippine passport, foreign passports, Philippine visas, foreign visas, align it with the new Passport Act and our international obligations. Yun ang kanilang gagawin. So, skip muna tayo. So, we're now on Article 174, and the DFA has 7 days to submit. Thank you. Article 174 is falsification of public, official, or commercial documents. Public, official, or commercial documents. Any insights, Prosecutor Nohara?
I'm just looking at my notes here that we have already adopted or retained Articles 171 and 172 of the revised penal code. I hope Attorney Jean will
172 of the revised penal code,
yes,
not the proposal.
Not the proposal. In lieu of Article 174, we're retaining the original provisions of our revised penal code.
I'm handed a document. Para passively worded. Nakita niyo naman si Comsec. Comsec handed me a document. It says suggested revisions to several articles of the proposed Code of Crimes. There's a proposal, this is from the UP Law Center, a proposal for falsification of documents under Articles 174, 175, 176. Do you have the submission? The rest, do you have the submission from UP Law Center? If not, I'll read it. The proposal reorganizes the falsification provisions of the revised penal code by classifying offenses according to the type of document falsified. Number 1, public, official, or commercial documents. And number 2, private documents. This creates a clearer and more systematic framework and addresses the confusion under existing Articles 171 and 172, which simultaneously classify offenses based on the offender, the nature of the document, and the use of the falsified document. So, when was this submitted, Comsec? Today. So, given that, Attorney Estigoy, when can you submit?
Your Honor, actually, it's already included in that submission. And we're merely proposing to retain what's already currently being proposed by the DOJ and UP Law Center draft, because we have a similar draft for this falsification of documents.
Oh, I see.
If I recall correctly, we were asked why we merged both articles, and under page 3 is actually our explanation.
It's a long explanation. So on page 3, recommendation of proposed organization. But on page 4, you have the proposal, no? And you're saying this proposal is reflected on the table, word for word.
Your Honor,
Professor Borja.
except for the penalty of prison correctional, because it seems that the penalty of prison correctional here was merely adopted by the DOJ because we have our own penalty of corrective 1 in our draft. So we simply propose to retain the old penalty in the RPC, which is prison correctional in its medium and maximum periods. Apart from that,
this is for Article 174.
Yes, Your Honor.
But on your submission here, it says prison correctional.
Yes, there's also a typographical error, and we're making clarification as of this moment. That
So it's
not
prison
only,
correctional, medium, and maximum.
Yes, Your Honor.
So you are borrowing that from the Revised Penal Code.
Yes, Your Honor.
So ito. So on Article 174 here, it's just clarify, prison correctional is medium to maximum. Medium to maximum. Okay, any comments on Article 174? But I agree, you should distinguish between the documents. You should distinguish based on the type of documents. So Article 74 makes clear that this applies to public, official, or commercial documents and not private. And then with respect to private documents, that will be dealt with in the subsequent section, Article 175. Tapos, but first, any comment on the prohibited acts, perhaps, under Article 174? These are traditional definitions of falsification. Counterfeiting, causing it to appear that somebody participate, attributing, making untrue statement, altering true dates, making alteration or intercalation, issuing an authentic form of document purporting to be a copy of an original when no such original exists. Okay. So these forms of falsification, I mean, I'm not disputing that these constitute falsification. Where did you get this list? How did you compile the list?
Your Honor, the list is from the RPC. We merely streamlined the articles. So we did not make any substantial changes. If you will compare it with Articles 171 and 172 of the Revised Penal Code, it has the same list. It's just we streamlined the articles so that instead of simultaneously classifying the documents, we made it clearer.
Okay, yeah, I see that. That's in a few pages back before that, the list. So this list is as long as the list in the RPC. Okay, here's another question. Is this an exclusive list? Are there other forms of falsification that we can imagine or contemplate? How else can we falsify? Is there any danger in having? I agree this should be included, but are we overlooking other forms of falsification? Can you think of any? Prosecutor
I
Gamora.
was thinking because during the COVID-19, there are signatures that are registered with I think it's DTI, DICT. And how about if those signatures are falsified
Here, counterfeiting any handwriting signature.
Yes,
That
Your
would be
Honor.
signature.
Yes, I'm aware, Your Honor, with the provisions on the cyber, what's that?
Cybercrime Prevention Act of
Yes,
2012.
yes, Your Honor, that when we use computer system to falsify, but if we can include this as a separate act, Your Honor, falsifying signatures that were already registered.
Is that
If it is viable, Your Honor.
registered signatures? Is the DICT here? Is there? Well, first question, is that necessary given the provision before us, which seems to be sufficiently broad? But anyway, Attorney Estigoy and then Prosecutor Ocampo.
If I recall correctly, Your Honor, Cybercrime Prevention Act is actually a proposed new title under both the bills pending right now.
Yes.
We're still about to discuss that in the near future, hopefully. But as per our records, we substantially verbatim reproduced the whole Cybercrime Prevention Act under that new title. So if it's under if it's under that law, then it should be under that title.
In other words, Attorney Estigoy, there's no reason to rock the boat now.
Yes.
Let's not rock the boat anymore.
Mahirap.
Okay. Any other comments on Article 174, Professor Borja? And then we'll hear from Attorney Barito.
Thank you, Your Honor. This is actually an academic discussion which perhaps may happen in real life. Another mode of falsification that is not included in the list is what Justice Reyes brought up in his book. Let's say, for example, a person is illiterate, does not know how to read and write, and then somebody makes up a signature of that person. It may not fall under the other modes of falsification, such as counterfeiting or imitating, because there's nothing to imitate in the first place. So if we're going to add another mode of falsification, maybe we could do that.
Would that be number 3? Or number 2 or 3? Causing it to appear that persons have participated in any act or proceeding when they did not, in fact, so participate. Or attributing to persons, in this case the illiterate, who have participated in an act other than those that, in fact, made by them.
I think.
Parang nandun na yun eh.
Yes, sir. Yes,
Well,
Your Honor.
Yes, Your Honor, but I'm pertaining to the signature itself. Apart from whatever stated in the document, the person should attest to what really took place based on the contents of the document. Kasi pipirma siya sa dulo eh. So, ibang mode of falsification yung may description how the person participated. Let's say he sold his land without his authority. That's a falsification dun sa deed of sale. Pero iba pa rin yung dun sa pumirma siya kasi hindi naman talaga siya marunong pumirma in the first place. And that may not fall under counterfeiting or imitating any handwriting. And according to Justice Reyes, it's a form of feigning. It's a new term, feigning.
Feigning, signature.
Feigning.
Feigning or feigning? Feigning.
May we know from, yes, Mr. Chair.
Prosecutor Ocampo.
May we know from Professor Borja, where in this enumeration of the different acts of counterfeiting, are we going to include that what we call feigning? Would it be proper to say feigning a signature?
Yes, sir. Yes, sir.
So we can include it in enumeration number 1, counterfeiting or initiating any handwriting, signature or rubric, or feigning a signature.
Yes, sir. Or we could just make
Mr.
it of
Chair.
record that it is included in that particular act already.
Oh, tingin ko parang included na. But we'll hear from the public attorney, Attorney Barito.
Mr. Chair, in paragraph 1, can we also include thumbprint? Because under the notarial, under the rules of notarial, uh, a thumb mark or a thumbprint is an alternative to signature. Thank you.
But do we need to include that? Because if you cause it to appear that a person participated, or attributing the person to participate, kasi I think we might be overworking the first item, but overlooking or glossing over the other prohibited acts, causing it to appear. Oh, paano pineke yun? Yung notarial, pinalitan ng date, anong ginawa? Attorney Barido, in your example.
Mr. Chair, I'm pertaining to the thumbprint.
Thumbprint?
As a means of signing a document.
Yeah. So, if somebody falsifies the thumbprint, right? So basically the person, okay, si Juan, she is the one who's supposed to affix his thumbprint. And somebody affixes the thumbprint of Pedro as the thumbprint of Juan, right? So Pedro made it appear, caused it to appear that that Juan participated when he did not. That's number 2.
Mr. Chair, with respect to yun pong mga nauuso ngayon ng mga 3D printing na pwede pong makopy yung thumbprint na for example ay nakuha online or kung sa scanning whatsoever, then yung mismong thumb mark po nung tao yung subject and not just
right, but you did not counterfeit the thumbprint. That's a thumbprint of Pedro. But you made it appear that Juan participated. Hindi mo pinikim yung thumbprint. Okay. One is, again, si Aida Lorna at si Fiona lang gagamitin natin every time. Si Aida is supposed to affix her thumbprint. But Lorna affixed her thumbprint to mislead the public that it is Aida's. Okay? So the question, was it counterfeit? Did Lorna counterfeit the signature, the thumbprint of Aida? No. No, because it's Lorna's thumbprint, right? But what the violation there, that she caused it to appear that Aida participated in an ACRO proceeding when in fact she did not so participate. So that's a violation of number 2, not 1.
Okay. Thank you, Your Honor.
Prosecutor Cristoria.
I think that would be the same matter with the example given by Attorney Burha, Mr. Chair.
Yes.
Because the illiterate person does not actually have a signature, but
Yes.
somebody signed for the illiterate person, sir. So it's
Yes.
the culprit made it appear that the illiterate person participated in.
Yes, and I think what the prosecution would do, it would allege multiple prohibited acts. By counterfeiting ganyan, or causing it to appear, or attributing to the person a particular an act which he, other than those that he in fact made. You would do 1, 2, or 3. Right? 2. That's the nature of falsification. I did not participate, but you made it appear, the accused made it appear that I participated. Of course, that would not be a believable misrepresentation unless they imitate my signature. Right? In which case, that would be also 1. But you can't be prosecuted for 1 and 2. Right? You cannot be prosecuted for 1 and 2. Because that would be double jeopardy. Tama? Prosecutor Abadia.
If there are 2 acts, Mr. Chair, then we will file under paragraph 1 and also under paragraph 2.
But there's
If
only
not-
one act eh.
If one act, then we have to choose either counterfeiting or causing it to appear.
If Aida imitates the signature, I'm sorry, if Lorna imitates the signature of Aida to make it appear that Aida signed the document when she did not, would that be one or two? Or both?
It can be both, Mr. Chair.
Oh yeah,
In the information.
okay.
Anyway, it's the same penalty, Mr. Chair.
And it's arises from the same act or
Same act,
omission.
yes,
So that would be an exception to double jeopardy. Okay. So is there any need to, can you think of other instances? If not, we'll move on to the next. And I just wanted to point out that the penalty of prisión mayor shall be imposed upon the following persons if they committed the acts of falsification as defined in punishment in this article. Public officers, ayan o. So government officials and notaries, provided they falsify public official commercial documents which they prepared, intervened. Oh yeah, okay. And ecclesiastical ministers, provided they falsify public official commercial documents that may affect the civil status of persons. Ito yung ecclesiastical ministers. Are you referring to the marital status? Ano yung Bakit ecclesiastical ministers?
Your Honor,
Prosecutor
I think the reference to ecclesiastical minister refers to the act of falsifying some baptismal certificate, for example, when it affects the civil status or the status of the person, such as the date of birth and the age of that person. So the liability of the ecclesiastical minister is limited only to that act under existing jurisprudence.
Oh.
So we included it here to make it more clear that the liability of the ecclesiastical minister is only with respect to that act. Kasi doon sa present RPC, hindi siya na masyadong na i-explain or it is not stated so clearly that nilagay lang public officers, notary public, or ecclesiastical minister. Nilump siya into one. In our proposed draft, we enumerated the liability of the public officer and as one, paragraph 1 or number 1, and ecclesiastical minister as number 2. Yun lang po.
In the under the revised penal code, it says the same penalty shall be imposed upon any ecclesiastical minister who shall commit any of the offenses enumerated in the preceding paragraphs of this article with respect to any record or document of such character that its falsification may affect the civil status of the persons. So yung binanggit nyo po ay wala namang mention, there's no mention of public officers here.
In Article 171, Mr. Chair.
171.
Yes.
Yun nga po yung binasa ko. It's Article
Yes.
171.
Parang nilamp kasi doon, walang classification whether or not an ecclesiastical minister can also commit those 7 or 8 acts punishable. But jurisprudence nagsasabi na na-involve lang si ecclesiastical minister when the document or the falsification affects the status of the person.
Civil status.
So, civil status. In-include ko dyan, yung, for example, is the act of issuing a falsified baptismal certificate sa Roman Catholic Church. Meron kasing ganun eh. It can, the baptismal certificate can also be used as a secondary evidence in the judicial proceeding.
So in other words, you're saying that the ecclesiastical minister would not have so now we're talking about public official or commercial documents. So So the ecclesiastical minister would not have an opportunity to actually falsify public official documents, and that the only person who could actually falsify public official documents are public officials. So therefore, you inserted near the end, number 1, yung public officers, public employees, or notaries public, provided they falsify public official and commercial documents. Nililaw nyo lang. Meron ho bang pagtutol yung iba? What about the solemnizing officer? Sino ho ba yung ecclesiastical minister? What is the who are we referring to? Ecclesiastical minister. Alam kong taong simbahan yan eh. A religious person. Ecclesiastical, di ba? So, is this still current when you say ecclesiastical ministers? Are we unduly limiting it to at saka ministers ginagamit, not priests? Anong sabi ni Reyes sa ecclesiastical minister? Any concern regarding ecclesiastical ministers? Prosecutor Ocampo.
Yes, Your Honor, I think there is a confusion here. According to Professor Nohara, ecclesiastical minister, Nohara, yes, Mr. Chair, that the ecclesiastical ministers may be liable, for example, when they falsify baptismal certificate, which would, in effect, affect the civil status of the person alluded to in the said certificate. May we know if this, at the time of the falsification of the baptismal certificate, how do we classify the baptismal certificate? Is it private or public? So because it says here, ecclesiastical minister provided they falsify public, official, or commercial document. But at the time they falsify, that baptismal certificate is classified as a private document. Unlike a person who solemnized marriage, that contract of marriage is deemed to be a public document.
Well, yes. That's one. Also, it's still not clear to me what an ecclesiastical minister is. Number one. Number two, how that ecclesiastical minister would have access to public, official, and commercial documents.
And we have also to determine, Mr. Chair, when are we going to classify a baptismal certificate as a public document? Is it a need that it be notarized in order to be a public document, sir? Yeah, Mr. Chair?
The public attorney would like to be heard.
Attorney Hernandez.
Yes,
Mr.
Attorney
Chair.
Hernandez, you have the floor.
The only scenario that I can think of ecclesiastical ministers who can affect the civil status of persons is if they are solemnizing marriages. So that's the only
Question, Attorney Hernandez. What does civil status mean?
converting a person's status, like from single to married.
Yeah. So it's
So-
marital status is a civil status.
Yes, Mr. Chair.
Also, what about legitimacy? Illegitimacy.
If
Is that
for
is that civil status?
yes.
Okay.
So, if a couple, man and woman, gets a falsified marriage certificate, and then they will use that for court proceedings to legitimize a child. So, makaka-affect din siya sa
Okay.
legitimacy.
Okay.
So, sa civil status. So, the very document, yung certificate of marriage, dun yung avenue na mag-a-apply ito. So, and then, although I was thinking, bakit ecclesiastical ministers
Yun nga
lang? Bakit hindi yung ibang solemnizing officers?
Yeah.
Ba't hindi si judge? Ba't
Is
hindi si
there
mayor?
is there a definition for
Your Honor,
ecclesiastical minister?
Your Honor, just for that definition, Your Honor.
Prosecutor Ricamora.
Ecclesiastical minister, Your Honor, for the record, is a person authorized by a religious institution to perform pastoral, spiritual, and administrative duties within the church.
Okay. Okay, it's not just marriage. It could be other, like baptism. What other administrative work? Attorney Hernandez.
As far as I know, Mr. Chair, ecclesiastical ministers still get, I don't know the term, accreditation from the government in order to be able to solemnize valid marriages.
Yes.
So that's their distinction.
Prosecutor Ricamora.
That is correct, Your Honor, only for purposes of administrating marriages. But there are other functionalities there
Right.
inside the church.
Baptism is
Yes,
one.
like those who are in custody.
Confirmation
Yes.
is another one.
The term, Your Honor, is broad enough to cover
Okay.
all workers in the church.
So we are agreed on the definition of ecclesiastical ministers. Okay. Putting that aside, the question then is, they falsify public official or commercial documents. Well, what is the difference between a public document and an official document? Or is that just a, lawyerly language of like change, alter, modify, revise, amend, which all mean the same thing? What is the difference between public and official document? Yes, Attorney Hernandez.
It appears to be similar. It appears to be same. And also, perhaps the document that is referred to in this paragraph only refers to those that are registered maybe with the PSA. Those similar kind of documents like marriage certificate or, I don't know. Hindi naman pwedeng kasama yung birth certificate kasi hindi naman pumipirma yung pari doon.
Tsaka the trust is different eh.
Hindi rin naman pumipirma yung pari sa commercial document. So,
Yes. It's like they don't have an opportunity to falsify. It has no relevance to them. I think what's being penalized here is that the unique position that they have, the advantage they have, because they're issuing the document, or they have custody of the document. That's what's being penalized here. But the mere fact that the ecclesiastical minister falsifies a public document doesn't make it any worse, or should not make it any worse. Yun po. That's why, if you look at the original wording under the revised penal code, look, I think this is deliberately worded. It says, the same penalty shall be imposed upon ecclesiastical minister who shall commit any of the offenses enumerated in the preceding paragraphs with respect to any record or document of such character that its falsification may affect the civil status of the person. It is not saying that it's falsifying a public, official, or commercial document. It's saying that it's falsifying any document in its custody. Because you cannot falsify something that is not in your custody. And the falsification of the document in your custody may affect the civil status of the person. So it is not the same. It's not the same as falsifying public, official, or commercial documents. Hindi naman po ganun yun eh. Do you see the distinction? Ha? So, ang akin, may we revert to the original language, or at least come closer to it. Now, with respect to public officers and employees, yes, I see, provided they falsify public, official, or commercial documents which they prepared, intervene, or have custody of. See, yun, malinaw yun. Basta it's in your custody and you falsified it. Actually, in the course of their performance of their official duty, so it's in their official custody. That's what the first number 1 refers to, no? In the course of their performance of their official duties, is the unique advantage they have. The fact that they have the document officially, right? And then they took advantage of opportunity to falsify, and therefore they should be penalized more heavily. Yan ang pinagbabawal dyan eh. Shall be imposed upon the if they, I'm sorry, not necessarily heavily. Okay?
Yes, Mr. Chair.
Yung sa second, do you agree that we should revise this? Yung ecclesiastical ministers, perhaps ecclesiastical ministers, provided they falsify any record or document that may affect the civil status of the person. Yun lang yun.
Any document na lang.
Any document.
We agree for the deletion of public, commercial, or whether it is official.
Yes, Your Honor.
We can just refer back to the original, any document which may affect the civil status of a person. That is more clear,
Okay.
Mr. Chair, and
Okay,
practical.
Okay. Prosecutor Ocampo.
Yes, Your Honor. We must not differentiate anymore whether it's public, official, or commercial, falsified by an ecclesiastical officer. Because a good illustration of this, for example, in an action for paternity filiation, and in order to prove that the father is the Mr. A is the biological father of Mr. B, they made it appear that he was baptized in a certain congregation, and on the details, Mr. A was identified as the father. If we will only be focused on the falsification of public, official, commercial document, like as we have agreed before, a baptismal certificate is not a public or commercial document. So he could not be indicted for falsification. Unless, of course, if he testify before the court and affirm and identify the document, then he will have another case of forgery. So it's about time to not to limit the falsification of public or official or commercial document. All documents.
But here's an added wrinkle. Hindi natatapos dyan eh. Since you made it any document that may affect the civil status of the persons, then that's not aligned with the heading, the title.
And that also draws the distinction between a public document and an official document. A public document, its source may be, it originates as a private document, and then when it is notarized, it becomes a public document. An official document is that for a record issued by a competent office or an authorized officer in the discharge of his function. Mr. Chair.
I see. That is the distinction between public and official.
Yes, Mr. Chair. Thank you.
But again, I go back to my question. Since now we have revised the number 2 concerning ecclesiastical ministers, so that they, falsify any documents that may affect the civil status, is no longer aligned with the title. Because the title is public, official, or commercial documents, and now you're talking about any document. And that's perhaps is the reason why, let me see. Paano yun? How do we deal with that? Any documents is not public official. It's not necessarily public official or commercial documents. So it may well be a falsification of a private document. Correct? It could be a private document. Professor Borja.
Thank you, Your Honor. Thank you, colleagues, for pointing, also Honorable Chairperson, for pointing that out, that it's not only public documents where ecclesiastical ministers can falsify documents that may affect civil status of persons. My only worry here is, although it's meritorious to include ecclesiastical ministers, if we still include it under this section, it may seem that any document that may affect the civil status of a person may now become a public document because it's
Correct.
based on the heading.
Yes.
So we need to work around this. And I don't think it's feasible to also add another provision on falsification of a private document in the same length as the ecclesiastical minister as the offender. I'm trying to find a way to treat this situation as sui generis, wherein we're classifying falsification here at this point on the type of the document involved, whether it's public or private. But if it's done by an ecclesiastical minister and the document affects the civil status of a person, then it may either be public or private, but the penalty should be higher.
If it's falsification of a private document, it's penalized by arresto mayor, 1 million. So where will we insert ecclesiastical minister? It's out of place under Article 174.
Definitely,
It's
sir.
going to be out of place under Article 175. May or may not be, right?
Yes, sir.
Because an ecclesiastical minister, for example, can falsify a marriage contract. That's a public document. It can falsify a baptismal certificate, which is, I think, a private document. Diba? So, neither here nor there, not 174, not 175. I feel that it's premature to introduce it here. Kasi you've only it's premature to insert it in Article 174 because we have not talked about private documents. If we were to insert this, it would have to be like a second paragraph of 175 para merong reference back. What are your thoughts? It's just no, this is really style. Everyone's agreed that they should be penalized with the imposition of prisión mayor, no? Pero where do you insert that? Prosecutor Abadia.
Would it be possible, Mr. Chair, for us to just have a separate provision, or maybe in order to emphasize, we can have Article 174, falsification of public, official, or commercial documents, which specifically refers to private individuals as offenders. And then, since the penalty, the higher penalty of prisión mayor is imposed upon public officers, public employees, or can be another provision, and it can be entitled falsification by public officers, public employees, or notaries public. And then, Mr. Chair, another provision with the same penalty for ecclesiastical ministers, and it will be entitled falsification by ecclesiastical ministers, which includes priests, pastors, or imams, Mr. Chair. There's no mention, the mentioning of the public, commercial, or official documents will just be in the body, Mr. Chair,
So you're
but not in the
proposing
title.
from Article 174 and 175, you wish to make it
174,
Yo-
175, and 176, Mr. Chair.
176 would be falsification by...
By ecclesiastical ministers.
Bakit hindi na lang... I'm thinking you want to make 3 articles out of 2, right? Or
Out of-
4 articles out of 2.
3 articles out of 1, Mr. Chair, because presently it's just one Article 174.
Oh, okay.
I'm
No,
being-
I was including 175 in the count.
No, Mr. Chair.
So 3 articles out of 174.
Yes, Mr. Chair.
Why not just make 2 articles out of 174?
Um,
Because I was thinking, Article 174, falsification of public, official, or commercial documents, you know? It's by any person. And then, falsification of private documents would be the next. And then, falsification by public officers, employees and notaries public, and ecclesiastical ministers. 3.
Mr. Chair, my worry if we lump together public officers and ecclesiastical ministers, because we already agreed, Mr. Chair, that for public officers, it's going to be public, official, or commercial documents. However, for ecclesiastical ministers, we agreed that any record or document,
Kaya nga eh.
public or private.
Kaya nga the heading makes no reference to the type of documents but to the actor.
Okay.
So that you would have 2 paragraphs. The first paragraph is for public officials with respect to public or official or commercial documents.
Yeah.
And the second paragraph would be ecclesiasticals with respect to any document. So the heading would be falsification by public officers, public employees, or notaries publics, or ecclesiastical ministers.
That will be also okay,
So,
Mr. Chair.
so magiging ano yan. But to maintain the flow, 174 would be, hear me out, falsification of public, official, or commercial documents. Retaining everything, all the way to 8, and then you would delete the penalty prison by all the way to civil status of persons. And then after that, you go directly to Article 175, falsification of private documents, right? And then Article 176, falsification by public officers, public employees, notaries publics, or ecclesiastical ministers, right? Then the first paragraph would be, the penalty of prison shall be imposed upon the following persons if they commit the acts prohibited by, anong wording nun, in the preceding sections? Committed the acts of falsification, the acts of falsification enumerated in Articles 174, Article 174, number 1, public officers, public employees, notaries, provided they falsify blah, blah, just keep the wording, and the ecclesiastical ministers, provided they falsify any documents that may affect the civil status of persons. So in effect, yeah. Do you follow? Do you agree, Prosecutor Amadilla?
Mr. Chair, that will be reverting to Article 171 of the present revised penal code, which provides for falsification by public officer, employee, or notary, or ecclesiastic minister, Mr. Chair. Maybe we can also do that and then just follow the wording as in the draft, Mr. Chair.
Mr. Chair,
No,
may I say
no.
something?
Prosecutor Nahara.
We, based on this proposed draft, it seems that we are departing from the original text of the revised penal code under Article 171 and 172. In Article 171, we define disqualification based on the offenders. And the offenders are public officers or employees, notaries public, and ecclesiastical minister. While Article 172, we define falsification committed by a private individual or public officers, employees, or notaries public who do not take advantage of their position. In the present draft, Mr. Chair, we don't classify the crimes based on the offenders. We classify crimes based on the nature of documents. Kaya medyo nalalabuan tayo sa pagdidiscuss because we cannot apply which provision will be applicable dito sa proposed draft. So, nahihirapan tayong ilagay kung saan po pwesto si ecclesiastical minister simply because naiba na yung nature ng crime. Kasi ang private individual cannot commit falsification, yung number 7. Jurisprudence po yan. A private individual cannot issue in authenticated form a document. Hindi pwedeng makomit ng private individual yan. That can only be committed by a public officer because siya yung may custody, siya yung in possession of a certain document. Kunyari, birth certificate, certified true copy. That cannot be committed by a private individual simply because he is not the custodian of that particular document. That's why nalalabuan tayo ngayon. That's why we should redefine whether we will revert back to the revised penal code or will change these articles or crimes differently now.
171. Okay. Bakit pa binago natin? It seems to work. It seems to work. 171, 172 was working. Why did we change it? Professor Borja.
Mr. Chair, kasi nalabuan yan kasi yung jurisprudence with respect to the element of damage or intent to cause damage, hindi applicable yan sa official, sa commercial or public. Nagiging applicable lang yan sa private document. Kaya nilinaw ngayon sa proposed draft na iba yung element, iba na yung crime when it comes to falsification of private document. Kasi sa present wordings ng Article 172, there are 3 separate acts there. Iba yung treatment sa private, iba rin ang treatment sa public, official, or commercial document. Kasi doon sa official, commercial, and public document, it does not require as an element the damage or intent to cause damage, which is required in Act number 2 under Article 172. Kaya po nalabuan. So kung gusto po natin, bumalik na lang tayo sa dating.
Bumalik na lang tayo because when you look at Article 172, number 2, there it specifically mentions damage to the damage of a third party. But it's not, that language is not present in number 1, in the preceding paragraph. And yun lang eh. Malinaw naman. Malinaw naman eh. Why are we changing? Professor Borja.
Your Honor, thank you. I would apologize in advance if this is the only time that I would stand our position and would vehemently object
to this.
Firstly,
I don't see the vehemence.
Yes.
Yeah.
Firstly, I think we have already established that this is a crime against public interest. And the very nature of the document is so vital that it affects public interest. And as you may notice, under the title, Section 4, all of them are enumerated based on the type of documents involved. And perhaps it's one of the reasons why the elements of a falsification of public is different of a public document is different from a private document. And we have to make that clear, because I agree that it's confusing because of the different actors involved in the act of falsification. Now, perhaps to remedy that, I support the Honorable Chairperson's attempt to create also Prosecutor Abadia's proposal to create a separate provision. But you should not entitle it with falsification by a public officer or an ecclesiastical minister, because that will somehow put the attention away from the document and center on the actor. And it seems that we're creating a separate crime. We're not doing that. We're increasing the penalty.
Now I see the vehemence, but go ahead.
Because it just so happened that we're focusing on the document. But the circumstances surrounding the falsification, okay, differs from the offender and the type of document.
So how would you word it?
Maybe a separate provision saying that circumstances that would increase the penalty somehow. Something to that effect that would be synonymous to like a qualifying circumstance and not a separate and distinct crime. And because
like
of the title,
something like
circumstances that would
qualifying circumstances, something to do with the status or the custodian. But go ahead, Prosecutor Cristoria.
Thank you, Mr. Chair. I understand to some extent the position of Attorney Borja, but then again, Mr. Chair, I honestly could not picture a scenario wherein an ecclesiastical minister could somehow falsify a commercial document in a manner that it would affect the civil status of a person. Because a commercial document are those instruments that are being created and regulated by the Code of Commerce or mercantile laws, such as checks, bills of exchange, promissory notes, warehouse receipts. I really could not picture a situation, Mr. Chair, that the ecclesiastical minister could somehow falsify such document and affect the civil status of a person. Thank you, Mr. Chair.
Teka.
And Mr. Chair, if I may add.
Oh, yes.
If we are also to consider the type of document in this particular provision involving ecclesiastical ministers, and we deal with public documents, those are the documents that are created, acknowledged, notarized by competent public officers. So how would an ecclesiastical minister enter into the scene involving such public documents?
Yeah, the wording of the original wording of the revised penal code is with respect to ecclesiastical ministers is falsification of any document that
would be better.
No, that may affect the civil status. So it could not be the document itself, but it could be a document that will facilitate that will lead to that will mislead it could be a misrepresentation that will affect the civil status of a person in a different document. That's yun po yung wording. Any document side wording is with respect to any record or document of such character that its falsification may affect the civil status of the persons. So it's it's just it sets a stage or lays down the what do you call this? Lays the predicate or condition for it could be like an underlying document, not the document itself. But we're still on the issue raised by Professor Borja. Are we focusing on the type of documents or focusing on the perpetrator? Diba? Parang there's a misalignment as he points out. Now, is there a way around that? Or we could just be like, so what? If it's like, yeah, it's falsification of legislative, like when you read the text under the revised penal code, under 170, 171, 172, it clearly talks about private documents,
Your Honor,
contemplates public documents, certainly. So what if it's couched as falsification by public officer or falsification by private individuals? But Attorney Barido would like to speak.
Mr. Chair, I'm trying to imagine paano po nagagawa itong second paragraph, no, yung sa ecclesiastical ministers. And for me, somehow it is a sui generis type of falsification. Why, Mr. Chair? Because, for example, merong couple na gustong makasal, and then lalapit po sila sa isang ecclesiastical minister. Minister, para hindi na kami mapagastos, it's as if ilagay nyo na lang dun sa marriage certificate na kinasal kami sa ganitong araw, whatsoever. So, to my mind, pag prepare na ni ecclesiastical minister yung document na yon, that time, hindi pa siya considered na public. Pero by the time na dalhin na yon sa isang civil registry, i-accept na, ipaprocess na, and then eventually, pwede nang makakuha ng certified true copy, then it becomes a public document na can affect the civil status of certain persons. So, in the ultimate, naging public document din naman siya arising from the act of the ecclesiastical minister.
I see your point. Sorry, Attorney Hernan. I see your point that it's probably improbable, but you cannot discount the possibility. There is no harm, to my mind, in keeping it as is. That document could be a false certification. Okay, can you please certify that blah blah? And I'm a ecclesiastical minister. I issue a false certification that influences the government agency.
Yes.
So that would be an example, right? If I issue a false certification, it is a private certification. It's a private document, but it's intended for the consumption of a public agency, of a government agency, and they're influenced by it. Why? Ecclesiastical ministers do not lie. They're man of the cloth. They do not lie. Yun po yun eh. Di ba? Yun ang kaya nga ako, even if it's hard to imagine a situation where that might apply, is there a remote possibility that it may apply? If the answer is yes, future-proof it, is included. Sama na natin. Pero that's not the issue. The issue is the issue raised by Professor Borja. Do we focus on the nature of the documents or the nature or on the perpetrator? Diba? Kasi, if you look at the title, the section 4 focuses on the documents. And in fact, it starts with falsification of legislative documents. And then, all of a sudden, falsification by public officers. There is an implication na parang may implication that 171 refers to public documents. Why? Sabi, tama ba? Or am I misreading it? Public officer, employer, notary, who taking advantage of his official position. So parang it implies like official custody in the course of official business, he comes across this document and then commits any of the following acts. Tapos, before I turn to Prosecutor Nohara, and then sa 172, now, private individuals Public official document. Nakikita ko yung problem mo. Private document yung number 2. And the number 3 of 172 is there's no mention of commercial, no? In either 171 or 172. But Prosecutor Nahara.
Yes, Your Honor, that's the problem. Kaya I stated earlier, nag-iba kasi ng ihip ng hangin eh. Dati, nakafocus tayo sa offender, whether he is a public officer, etc., etc. For you to apply under existing jurisprudence, Article 171, the mere fact that the offender is a public officer does not make him criminally liable under 171. Kasi subject that to the condition that the public officer must take advantage of his official position. And the Supreme Court interpreted that phrase that a public officer is considered to have taken advantage of his position when he has the duty to make or to intervene, or if he has the official custody of the subject falsified document. Kasi pag hindi ka nag-take advantage ng official position mo, you're now the offender under Article 172. Yes. Kaya nalalabuan tayo ngayon kasi yung present revised penal code nakafocus sa offender. Ngayon, sa draft namin, nakafocus sa nature ng document.
Yes.
Kaya dito na, yun dapat ang issue na i-resolve natin.
Yun nga po. Pero mayroong vehement objection si Professor Bohara because he's looking at the section title, which focuses on the document. Ako naman, ang tanong ko, okay so what if it focuses on the document? Can't you just say falsification of by public officer, falsification of by private individuals, and then in the text for these sections, mention the documents above in the section. When you look at it, it's really style. Style yan eh. It's style. If we are I'm trying to imagine if I think again I go back to the deference. When in doubt, defer to the status quo. And then we should not be what do you call this? We should not be abolitionist, that we will abolish the status quo. Rather, we should make adjustments because it's a precedent. There's a history of jurisprudence, interpreting the existing provisions of the revised penal code. I would think twice before really turning it upside down, or because built in na yan eh. It's just a matter of for me, this undertaking to codify is really to make sure to revise or delete laws that are moot or that have been overtaken by events, no longer apply, or that maybe are discriminatory or show a male bias, or that is maybe harsh, or that has been misused. But for me, if it ain't broke, don't fix it. That is my approach. Meron ho bang mawawala kung we keep it like that? Because it poses a challenge on how to style. Meron ho bang mali? So that's the first question. In Article 170, 171, 172, I'm sorry, just 172 and 170, 171, 172 of the Revised Penal Code. What's wrong with it? Parang wala naman mali . certainly, we have you have the cases that Professor Nahara mentioned, which also Reyes cites, People versus Santiago Uy and U.S. versus Inosanto, on what taking advantage of official position means. So that's built into 171. And then we already, with respect to ecclesiastical ministers, we made clear that it refers to any document or record of such character that its falsification may affect the civil status. Nothing wrong with that. 172. Any private individual who shall commit any of the falsification enumerated. I know the concern of Professor Nohara that a private individual cannot commit issuing an authenticated form. But I don't need to state that. I don't need to state that because it's already impossible for him to commit. So it's just saying if I commit any, it's not saying that it can be committed. So if he cannot commit number 7, then so be it. He cannot commit it. So hindi ko na sasabihin yun. So isa akin, yung Article 172 number 1, okay na yun eh. He can commit, yes, he cannot issue an authenticated form. Hindi ko naman pinipilit, hindi ko naman sinasabi na he can commit it eh. Who commits any of that? If he cannot commit it, then so be it. Yun lang naman eh. May jurisprudence tayo doon. And then, going to number 2, any person who, to the damage of the third party or of the intent to cause such damage shall, in any commercial document, commit any of the acts of falsification enumerated in yan. Okay. Any person who shall knowingly introduce in evidence any, with intent to use, shall use any of the false documents embraced in the preceding section, article, or any of the foregoing subdivisions of this article shall be punished. Okay. Ayun. The only type of documents that was not mentioned specifically here is commercial documents in 171, 172. But commercial documents are private documents, correct? Tama ba? They're private documents. Prosecutor Abadia.
Thank you, Mr. Chair. May I respectfully suggest this? For Article 174
of the
proposed draft, Mr. Chair, instead of saying the penalty of prison mayor shall be imposed upon the following persons, maybe we can shorten it to the penalty.
174 of the proposed draft?
Yes, Mr. Chair, House Bill number 7142. We can say the penalty of prison mayor shall be imposed upon public officers.
174 starts with the penalty of prison correctional.
I'm sorry, Mr. Chair. On page 127, the one in caps lock.
Oh.
So we shorten it to the penalty of prison mayor shall be imposed upon public officers, public employees, or notaries public, provided that they falsify public official or commercial documents which they prepared, intervened in, or have custody of in the course of the performance of their official duties. And in order to accommodate the concern, vehement objection of Professor Borja, Mr. Chair, maybe we can revert to the original wordings in the revised penal code that says the same penalty shall be imposed upon any ecclesiastical minister who shall commit any of the offenses enumerated in the preceding paragraphs of this article with respect to any record or document of such character that its falsification may affect the civil status of persons, Mr. Chair.
Prosecutor, the only thing is that you revise Article 174. If you're adopting the revised penal code, you should be revising the revised penal code and inserting that paragraph. Because you're retaining more, you're keeping most of Article 171 and 172.
Yes.
So working on 172, how would you revise it?
I,
On 171.
I understand your concern, Mr. Chair. However, I'm also thinking about the concern of Professor Borja, because Professor Borja is saying that we should not focus on the offenders.
So how would you retitle
So
Article 171
my proposal,
of the
Mr.
revised
Chair,
penal code?
I'm sorry, Mr. Chair. My proposal, Mr. Chair, is that we retain the proposed draft on Article 174, which focuses on the falsification of public, official, or commercial documents. However, in order that there will be no additional provision, we reword the number 2 to use the one in paragraph 2 of Article 171 of the Revised Penal Code, Mr. Chair. But in order to do that, we also have to reword the 1, 2, 3 the one in page 127 on the penalty for public officers, public employees, or notaries public. Basically, Mr. Chair, it's just a matter of style because the essence is still the same. We just want to accommodate the concern of Professor Borja that this provision should focus on the nature of the crime, which is a violation of crimes against public interest, Mr. Chair.
What I see your point, but before that, let me just ask: why did we mention commercial documents here? In Articles 171 and 172, there's no mention of commercial documents, but we're mentioning commercial documents. Articles 171, 172 Revised Penal Code mention public and private documents.
Yes,
Bakit po commercial?
I think, Mr. Chair, it's because we included in this paragraph the falsification that can be committed by public officers, public employees, or notaries public.
But public officers can falsify private documents in their official custody. I feel that we're unduly limiting the documents to commercial documents. Why not just make it broad enough? Because what drives here and what's pivotal is official custody. So if a private document is in my official custody as a public official and I falsify that, then, di ba? It's di ba? Hindi. Why did we call it commercial?
Mr. Chair, are you
Yes.
saying that if the offender is a public officer, regardless of the nature of document, whether it's public, commercial, private, official, he can falsify it?
He can.
Yeah.
Yes, if he has access
Yes.
to it.
Thank you.
If he has official access to it,
Yes.
and if he takes advantage
I
of
agree
his,
with your view, Mr. Chair. Regardless whether he is regardless of the nature of document, a public officer can falsify a document.
Yes.
As long as he takes advantage of his official position.
And that's why the original wording works.
Yes, Your Honor. That's why we are amenable if we are going to revert back to the original provisions with some enhancement.
Ang tingin ko, honestly, I mean, how long have we had the revised penal code? Since 1932, this has survived scrutiny. I mean, notwithstanding the misalignment between the section title and the article heading, it's form. So if this works, I don't see any reason to change it. Yun ang tingin ko, unless you feel strongly, Attorney Stigoy.
Your Honor, actually our submission and proposal is the DOJ draft, which is under HB 7132. So this was actually their proposal that we are supporting. However, if the DOJ feels and the body feels that it is better to revert back to the RPC, then we submit to the wisdom of the body. The recommendation which under our impression is the same recommendation of the DOJ given their proposal, was that to address the confusion that's being experienced by practitioners with regard to these articles on public and private documents.
But I don't see what the confusion is. I don't see the confusion. The fact that the section says it focuses on documents that may be falsified, and then the two sections under that particular section, two articles, is, focuses on the perpetrator. There's no confusion because they're not reading the heading anyway. They're looking at the elements of the crime.
As per our record, Your Honor, the confusion comes from the simultaneous classification of offenses under, for example, Article 172, wherein it penalizes the falsification of private documents and then the use of the documents, as well as the falsification of several public documents.
Several public documents in Article 172. A private individual shall commit any of the falsification in any public or official document or letter exchange or any other kind of commercial document.
So the confusion comes from under Article 172, Your Honor. In number 1, it makes reference with falsification by private individual of any public or official document.
Yes.
And in number 2, it also talks about falsification of private document. And in number 3, it talks about the use of the falsified documents. That's why we supported the draft of the DOJ to classify the falsification according to documents.
But isn't the distinction here, with respect to Article 172, number 2, is the element to the damage of a third person or with intent to cause or such damage?
And then we also separated the crime of use of falsified documents, which is a separate provision, because I think we have had this discussion before that if the person is not the falsifier or the forger, then you can be held liable, and you use the falsified document, then you could be held liable for that crime. But if you're the falsifier and you use the document, you could not be held liable for two distinct crimes, only for falsification.
Any person shall knowingly introduce in evidence and judicial. So, in the present, under revised penal code, how is use prohibited? Use of falsified document prohibited?
Under Article 172, Paragraph 3 of the RPC,
who shall knowingly introduce or in evidence in any judicial proceeding or to the damage of another or with intent, or who with intent to cause the damage shall use any of the false documents enumerated in the next preceding article or in any foregone subdivision article. So, use is prohibited. And then in your use of false, in Article 176 of the DOJ draft, use of falsified documents, it says, knowingly introduces into evidence into judicial administration of any official documents. Okay, so if this is the approach, why can't we just revise number 3 of Article 172? You beef it up and incorporate basically what's stated in Article 176 of 7142.
Yes, Your Honor. We have no problem with that.
Can we just keep? Okay.
Yes,
so, for the benefit of the committee secretary, and also to make it of record, so we're keeping Articles 171, 172 of the revised penal code as revised. The revision being that we will we will revise 172 number 3 to include Article 176 of House Bill 7142. Okay na po ba tayo doon? Happy na kayo? We really feel, ako talaga, I feel that, we should really go slow in, drastically revising the revised penal code. Because unless there's a compelling reason, and, because otherwise, the more changes, the harder it is. Why did you change it? And I can just imagine how this will play out when we defend this before the Mother Committee and at plenary. And then, why did you change this? Why did you change? There's added comfort in saying, we did not change this. It's the same. We adopted it. Then tapos ang usapan. Diba? Ganun, madali eh. But, so we're after the compelling reasons. Maybe clarity, yes. But, let's not tank, if we can plug the holes instead of tanking the entire ship, we should definitely just plug the holes. Okay? So nasa ano tayo? Kaya pa isa. Kaya pa isa. Ano? 175 of UP.
Mr. Chair, we will disregard 174, 175, and 176 in the draft.
In the drafts, yes.
Yes, thank you. Thank you.
176. So we are now at 177. Tama? Falsification of wires, cable, telegraph, telephone messages, and use of said falsified. What is are there any changes here that are not apparent to me right now? Because I'm seeing this for the first time. Yes, the DICT is here to provide insights, given that what happened. Data interference under. Is there a need to update Article 177 given the advances in technology? Maybe hear from the DICT.
Good afternoon, Mr. Chair.
Sabi ng DICT, ang tagal ko na nakaupo dito, ngayon lang tinawag.
Opo.
Alam mo bakit? Gusto ko umabot ka sa lunch eh. Kasi masarap ang lunch. Go ahead.
Mr. Chair, we would like, first of all, we would like to note that under Article 173 of the Revised Penal Code, the penalty of prison correctional in its medium and maximum period shall be imposed upon officer or employee of the government or any private corporation or concern engaged in the service of sending or receiving cable or telephone message who utters a fictitious wireless telegraph or telephone message of any system or falsifies the same. On the other hand, Article 177 of the proposed Code of Crimes, the penalty was changed to prison correctional but without mention of its periods. Hence, the DICT would like to offer the following inputs. The DICT opposes the proposed revision that strips our courts of their discretion to adjust penalties based on mitigating or aggravating circumstances. Such discretion is essential to ensure that penalties are tempered with proportionality. We further object to the omission of the phrase in its medium and maximum periods, as this exclusion undermines the proper gradation of penalties. We also propose using the term electronic data message as defined in the rules of electronic evidence and in the Electronic Commerce Act of 2000 to be included in Article 177. Lastly, it is in our position that the penalty in case the falsification was committed through online means must be elevated to the next degree as prescribed by the Cybercrime Prevention Act of 2012. We have a proposed language for Article 177, Mr. Chair.
Kindly correct me if I'm wrong. My understanding is, I know that the Article 170 Revised Penal Code imposes prison correctional in its medium to maximum terms. Here, it says prison correctional. But I understand that if that is the wording, it's just without reference to the period, the court has discretion to impose minimum, medium, or maximum.
Yes, yes, yes.
So
Yes,
why
Mr.
would
Chair.
you oppose it?
Um,
The only reason you would oppose it is if you're objecting to the imposition of prison correctional in its minimum. Correct? Because
yes, correct.
in the status quo, under the status quo, the courts can impose prison correctional its medium and maximum periods.
It's in maximum period, yes.
Yes, right?
Correct, Mr. Chair.
Here, so when you say prison correctional, it comprehends or includes the medium and the maximum. So with respect to that, you're not opposing. You're not objecting.
Yes,
But you're in effect objecting to the imposition of prison correctional in its minimum.
in its medium, yeah po.
Tama? Nahulog ba? Ano yung nahulog? Ay, yung gavel? Nako, wala akong pupukpuk. Nako, wala akong pupukpuk. Tuloy-tuloy tayo hanggang mamaya. Pero wag wala inabot sa akin itong martilyo. Almost. Kaya ito, last 2 minutes. Di ba? That's number one. Number two, with respect to, I understand to modernize this, we need to include the electronic data message.
Yes,
No
yes,
problem
Mr.
with that.
Chair.
With respect to raising it 1 degree higher, there is a provision in Book 1, correct, that takes care of that. Now, if it's done online or all digitally, then it raises 1 degree. So that takes care of that, although it's not reflected here. But going back, so let's talk about the penalty. Di ba tama? So you don't want a lighter penalty in effect, correct?
Yes, Your Honor.
Tama ba yun? Any thoughts on that? Tama ba yung assumption ko? Let's ask the prosecutors. They're always in front of they're always in court. Okay, on one hand, prison correctional is medium and maximum period. That gives the court discretion to impose either prison correctional in its medium term or prison correctional in its maximum term, period. Maximum period, right? Tama pag ang ganito yung wording? You're the judge, Prosecutor Abadia. Oh. Guilty under Article 173. What term will you impose?
So, for this particular provision, Mr. Chair, Article 177 as proposed, it will be within the range of...
No, answer first. You're the judge. You're convicted presently under Article 173. Okay? 173 says prison correctional, its medium and maximum periods. What may you impose as imprisonment?
So, I can impose a penalty of prison correctional in its medium period with a range of 2 years, 4 months, and 1 day to prison correctional maximum, which is 6 years.
Okay,
imprisonment.
ganon. Okay.
Yes.
So those terms or periods that you impose are included in prison correctional, correct? Under Article 177.
Yes,
But-
included, Mr. Chair.
Yes, so that the judge can do that, but it cannot impose the minimum under 170 under 177. It can impose the minimum, right?
Yes, and that would be 6 months and 1 day.
Yeah, yun ang ayaw ng DICT.
Yes.
Ayaw niyang pababain. Tama? Okay.
Yes, Mr. Chairman.
So the DOJ, why did you propose to lower the penalties?
We have no personal knowledge as to why this was just mentioned. It just mentions prison correctional, Mr. Chair. However, if it is the concern of the DICT that they want it to be prison correctional in its medium and maximum periods, considering that it is also the one mentioned in the original revised penal code, then we can include
Okay.
medium to maximum, Mr. Chair.
Any objection to that, Attorney Stigoy? None? There being none, the gavel is in my hand. Oh! Okay,
Just to
Attorney
note
Stigoy, go.
for the committee's conference, Your Honor, As we all know, the DOJ's drafts the DOJ draft used the UP Law Center draft, and we actually have a very special nomenclature for penalty. Under our draft, prison correctional is corrective 1 and corrective 2. And in revising their draft, the DOJ may have overlooked this very specific detail. So I think when they look at corrective 1 and corrective 2, they just reverted it back to prison correctional. And they may have overlooked that there are some penalties that have medium to maximum or minimum to medium. Minimum to maximum.
In short, kasalanan ng DOJ.
And
Okay, okay lang. So we will revert to the original for the penalty. And also, what is the wording that you wish to include to modernize this provision?
The proposed language will be Article 177, falsification of wireless, cable, telegraph, telephone, and electronic data messages, and use of said falsified messages. And then the penalty of prison correctional in its medium and maximum period shall be imposed upon any officer or employee of the government or any private corporation or concern engaged in the service of sending or receiving wireless, cable, or telephone electronic data message, who utters a fictitious wireless, telegraph, telephone, or electronic message of any system or falsifies the same. Then we retain any person who shall use such falsified dispatch to the prejudice of a third party or with the intent to cause such prejudice shall suffer the penalty next lower in degree. Then we add, provided if the falsification was committed by, through, and with the use of information and communications technology, the next higher penalty will be imposed.
Okay. Okay, I think there's no problem, except that the last proviso, that's already in Book 1 eh. It's already in Book 1, so maybe we can delete that. Meron naman, nasa Book 1 na yun eh.
May I ask the...
Prosecutor Nara.
Mr. Chair, may I ask the representative from the DICT, what does electronically message mean? What does it mean? Does it include text messages sa smart or sa Globe, for example, or is it different from Facebook messages, Messenger messages, or Viber, or etc.?
As defined under the E-Commerce Act of 2000, it includes all forms of messaging that is made through electronic means.
So, sir, there's no distinction whether the message was sent through Globe or through Smart or through Facebook Messenger.
Per the Electronic Commerce Act, there's no distinction.
The question here, because I think the definition, this is one of the concerns raised previously, yung definition of terms. Are we going to have a definition of terms in the Code of Crimes?
Meron tayo? Okay.
Meron. So we would have to include that. Make sure it's consistent with the definition under special law. Is now an opportune time to end the discussion, suspend discussion consideration of the Code of Crimes? Are there any objections?
No vehement objection.
No vehement objection. Any non-vehement objection? Wala. There being none, the consideration of the Code of Crimes is suspended until July 14. Okay. Yun lang po. Maraming salamat po sa lahat ng dumalo. Thank you.
Thank you, Mr. Chair.